Okay. Good afternoon. Last hour. Aren't you lucky? I'm going to be on this side so I can do the check-in, but I'm not doing it right now. I want to make sure everybody's there. So, CGL, questions I get. Your client, Plumbers Inc., is contracted with GC Inc. to help construct a new residential condominium project, financed and designed by developers. Your client is contracting with GC Inc. They have to sign a contract, adding them as an additional insured, and they want and the GC says, my contract says you also got to have the developer as an insured, and you need BIMPD for operations, completed operations, and by the way, we want to waive a subrogation, which is fine. Okay. At least $2 million per occurrence, and we want completed operations for 6 years after the work is completed, and additional insured status. So, which actually makes sense because in Massachusetts, which didn't exist about 30 years ago, statutes of repose have come into play in the last couple decades. Not every state has them. When I first started in insurance, it was always discussed that if you made something, you were responsible for BI or PD for the life of the thing, the product or the thing. But when it came to builders and construction, over the course of time, they decided that after a certain number of years, maintenance issues come into play, and it's not all the negligence of the builder, it can now be the negligence of the current owner. And so different states have said, okay, after X amount of years, the contractor is no longer legally responsible. And in Massachusetts, it's 6. I think in Maine, it's 12. I'm not sure, but you can Google statutes of repose in each state, not each state that has them will tell you the maximum amount of time that builders will be legally responsible. And so that should, and it's interesting, some contracts ask for less than 6 years. If I'm a contractor, I'm going to ask for the statute of repose time period, but whatever. And so just a contract, you know, subcontractors who indemnify and hold harmless, blah, 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 to the extent, you know, this is a contract you'll never see, but I wrote it, so whatever. And whole or in part, I tried to make it like the endorsements read, but, so the insurance section requires, can the insurance section require a certain addition limit? Have you ever seen contracts where they say they want certain additions of endorsements, which could happen? You know, they want you to be responsible for all claims. That's all is a nebulous word, but, you know, are you insured for everything? Now, you can make yourself responsible for everything, but I have never seen a policy that covers everything, but you signed it, I didn't. I can do the best I can for you. And, you know, you've got to be responsible for the subcontractors, suppliers, manufacturers. You've got to hold them all harmless. Yay. So, what endorsement would work best to meet all the additional insured requirements? And not necessarily the one they have on their policy. You know, for a while, a lot of big construction organizations wanted the 1985 endorsement. I mean, that's a joke. I mean, what year is it now? Or they'll say 1985 or its equivalent. There is no such thing. I can tell you what you got. I can put what you got, but there really is no real equivalent to the 1985 version. I hear now that they've given up on the 1985 version, which that endorsement made you an additional insured for premises operations and products and completed operations. Now you need 2 endorsements. And some organizations want the 2001 edition. There's a 2004 edition, there's a 2013 edition. You know, if I can't get that for you, you know, when it comes to writing the certificate, I'm going to put the edition date. Put that on the counter. Okay. Okay. Good thing is, don't touch it. Okay. I'll do the check-in now, and then I won't have to worry about it until I'm done. So that'll. Okay, here we go. So, this is the first of 2. You already know I'm going to do the last one right before we're done, so that's fine too. The downsize the screen, put in your name, you'll get a little thank you, life is good, and away we go. Okay. Lose my train of thought. That's okay. Okay. So, Okay. So, where am I? Okay, 1985. I mean, we're in 2018. I don't know any company that uses them. But this is the specified additional insured. And can you write that whole contracted developer can you write a whole Stephen King novel on this? I mean, theoretically, you can. And it gives you the ability to write everything that the insured has accepted responsibility to add as an additional insured. And this one gives you premises, operations, and products, and it says arising out of, so it also means it gives you a sole fault coverage, which is why we don't like it anymore. So there is nothing. Now we have two endorsements. You get an additional insured premises operations, and you get an additional insured completed operations. If you get the 2001, you're about as close to 1985 as possible, but you got two endorsements and two premium charges. So the CG 2010 is specifying we limited you to ongoing operations, but we gave you arising out of. And from different court cases for different situations, arising out of has been deemed to maybe give the named entity sole fault coverage, and so that's what they're still looking for, to find their coverage through your policy. And this would be premises operations, and we remind you we don't do completed operations. And so we have CG 2010, 2001 version, liability arising out of your work. So again, could give them sole fault coverage for, stuff that's done on the job site. And technically you can type in as many entities as the contract requires. And it is as close to 1985 as possible. But because the words arising out of have been deemed to provide sole fault coverage for the additional insured, and ISO suggests that an additional insured should not get sole fault coverage from the policy to which they are attached. They should get it from their own. They changed endorsements in 2004 and then again in 2013. So that sole fault coverage is gone, that you only get additional insured status out of my policy if I'm at least 1% at fault. And in Massachusetts, if I'm at least 1% at fault, that contract I signed that assumed all responsibility is honored. But if I am not at fault at all, that contract would be void in the state of Massachusetts. So 2004, we now say in whole or in part. So if the named insured under the policy is at least 1% at fault, then we give insured status. Again, we can have a big lump of whoever, the GC, every other subcontractor, the supplier, whatever the contract requires, I can type in here, theoretically. And again, it's only premises operations. So I would, need a completed operations. Again, it's only ongoing operations where I'm at least 1% at fault. So I've got the same situation, completed operations, 2004. As long as the named insured is 1% at fault, and they can be 99% at fault, they find insured status. If they want a rising out of, you're going to have to find a company that provides 2001 edition dates. And we're now in 2018, so I don't know, have all your companies gone to the 2004 version? It is what it is. So, now I've had questions, and the agent said, well, I've got the automatic additional insured on the policy, doesn't that do the same thing? And the answer to that would be no. It's a different endorsement. You might want it to be the same thing, but it's not the same thing. And pretty much, this got a lot more words on it than if you go back to this endorsement here. That's only got a little bit of a paragraph in that. The automatic additional insured has extra information in it. It's got a whole separate exclusion in it that does not exist in the name, the scheduled endorsement where I can list everybody. And unfortunately with this endorsement, it starts off saying automatic status when required in construction agreement with you. Well, when I signed with the GC, I accepted responsibility, for my actions that also involve the GC, the developer, the designer, the planner, the architect, whoever the GC told me I had to assume responsibility for. The problem is this endorsement doesn't necessarily do that. We say you get, when you are performing operations, when you and such person or such organization have agreed in writing or in a contract or agreement. Somebody asked me, you know, they don't have a formal contract. Does this activate coverage? Well, is there an agreement? I mean, it doesn't have to be a 9,000-page legal contract. Could you be in a bar tonight and write something on a cocktail napkin where you're going to do work for me tomorrow and you're going to assume responsibility for me when you're doing work for me? And is that not an agreement? I mean, so it has to be in writing. It doesn't have to be a 9,000-page contract. And that has gone to court. You know, companies say, oh, it's not a contract. Well, then take the word agreement out of the endorsement. But that's not the problem. The problem is you in the contract assumed responsibility of a lot of different organizations because the GC has the responsibility for those organizations and wants you to assume it too. But the problem is there's only two entities signing that contract, you and that GC. And so therefore all those other entities do not necessarily find additional insured status with this automatic additional insured. If you did the scheduled one when you typed all their little names on it, then they are additional insureds. But this automatic additional insured endorsement, CG 2033, which has been around for a long time, does not necessarily pick up anybody else other than the entity that you signed the contract with. The 2001 version does say arising out of, so that's good, you know. But we've got a whole exclusion here regarding BI or PD arising out of your responsibility for the architect and whatnot. So it's not blanket. It has a little bit of problem. Again, rising out of is good news. Again, premises operations. But it has this exclusion in it. So if they ask for the CG 2010, and your insured has a CG 2033 on their policy already, is this meeting the contract? I'm going to say no. If they ask for a particular endorsement, then, and you don't give it to them, then no, it's not the same thing. It's not the same number, and it's not the same thing. Your insured doesn't want to pay for the other endorsement. The company doesn't want to offer the other endorsement, fine, but it is not the same thing, period. So there you go. Now there's a 2004 version, which, like the scheduled endorsement, the only thing it says, I have to be at least 1% at fault. ISO got rid of the words arising out of because in court, lawyers got more mileage out of them. And ISO's answer on all of their filings is, if the named insured is not at least 1% at fault, then the entity should not find insured status. They should go to their own policy, which I think is a darn good idea. But so I hear from agents that some of the contracts are specifying that it be a 2001 version. They gave up on 1985. They asked for a 2001 version, and they asked for the CG 2010, and this is what you got, then it's not meeting the contract requirements. And I think I would put the addition date on the certificate of insurance. You can do what you want. I'm not telling you what to do or what not to do. But I can't be I wouldn't type anything on the certificate that's not true. So they do get additional insured status for coverage A and coverage B. That's great. But we got a little bit of a problem. We still, have a problem with the exclusion, like we did in 2001, regarding assumption of professional liability for the architect, engineer, and surveyor. That's a whole different additional insured endorsement. CG 2010 could have done that, didn't have the exclusion in it. This one does. And like the CG 2010, it's a premises operations only. If you need to give them insured status for 6 years for completed operation, it's an entirely different endorsement. And we do, I didn't point this out before, but we know, when does the automatic additional insured endorsement end? When I'm done working. But technically, if you read the CG 2010, it says ongoing operation, so when I'm done working for you, you're done being an additional insured, and then I need to kick in with the completed operations. So if your company writes their own, I don't have any idea. And a lot of contracts ask for blanket. If the company doesn't call it blanket, then I want to say you've got an automatic additional insured endorsement. ISO doesn't use the word blanket. Particular companies might. And again, we need the CG 2037 if you need to prove additional insured status for when you're done, should something go awry, completed operations. So, there you go. So, and then there's a 2013 version. I mean, ISO just doesn't stop. You think you get used to an endorsement, and we keep changing it. And technically, the changes on the 2013 are really good for my insured, but they just keep the other entity from getting anything more out of my policy than the contract required. If the contract requires $1 million, and my policy is a $2 million limit, and I make you an automatic additional insured, or I make you a scheduled insured, could you access the whole $2 million of my limit? And you could. Under the 2013, we fixed that. And can a policy be broader than a contract? And can a policy almost be broader than a law? So we added 3 things to the endorsements. All the ISO went systematically through all their additional insured endorsements and add these 3 things. That we won't give you anything that's contrary to the law. So if they asked you to make them an additional insured for sole fault, that's contrary to our law. That would not be honored. It wouldn't be honored anyways, but you just have to go to court for it. Now the company would say no. And if they only ask you for BI or PD, even though the endorsement says you can be an additional insured for BI and PD or personal injury and advertising injury, if the contract only asks for BI or PD, this endorsement's now going to limit you to what you asked for in the contract. Whereas if you look at the older versions, it's just, you only asked for BI or PD, I made you an additional insured. Can you access my personal injury and advertising injury too? Yes, you can. Because insurance can be broader than the contract. But the new language is no. Why should we be giving you more than what you asked for? If you're not smart enough to ask for the world, then we're not going to have to give it to you. And then the last part, which is on the next page, which I don't know if I put here. No, I didn't. The last part is you can't ask for more than the limit. So if the policy is $2 million and the contract only asks for $1 million, you only get $1 million. Which I think the 2013 is great for my client. Because I write the little guy. I'll write the big guy. Well, now I guess they'll have to up the ante on their contracts. But why should you why insurance can be broader than the contract? Now we're saying no, the contract can limit. If you don't ask for enough, too bad. We have the same thing on the 2004, the scheduled insured. So this is where you can ask for a number of people, and if they're all listed, then they all become additional insureds. Completed operations. No, that is the CG 2030. No, premises operations. Again, no sole fault. We have those 3. Can't be brought. You can't ask for anything against the law. It will void the insurance. You can't ask for anything. You don't get anything you didn't ask for. So if you only ask for BIPD, you don't get personal injury. And if you ask for less than the limit of the policy, you can't get anything more than that. I got other things to do. Oh, boy. Okay. Oh, there it is. Required by the contract or agreement. So 2013 are good for the client, my client. They're not that much different than the 2004, but after 2001, we no longer say arising out of. And so if the contract is asking for a 2001 version and you can't provide it, you should tell your client. Okay, named entity, completed operations. Again, 2013, we'll put those 3 things in. Can't be contrary to the law. You don't get anything you didn't ask for in the contract, and you don't get a higher limit than what the contract required. So completed operations is scheduled. Does anybody have a company that does blanket completed operations endorsement? Because ISO hasn't created one. They have blanket operations, but not blanket completed operations. So, every contract I have, I'd have to do this endorsement, which again, I can type in a litany of additional insureds, which can be helpful. So back to the issue of I contracted with the GC, and in that contract, the GC wanted me to add other entities as an additional insured, and then there's a claim that I was part of. Does this automatic additional insured invoke all of the entities that I contractually committed to add as additional insureds? And it's been litigated that no, it doesn't. I signed the contract with the GC, they're an additional insured, but all of the litany of other entities don't find additional insured status. Oh, what? Okay, no, yeah. Oh, there you go. Oh. Where am I going to find it? Here, 9,000 feet. And this is one of the court cases, that, I signed a contract assuming responsibility for a bunch of different entities. I have the CG 2033. It's operations claim. A bunch of different entities get sued, and the company said, we're not paying it, and it went to court. And pretty much Westfield Insurance versus FCL Builders, automatic additional insured did not pull in every other entity as additional insured. So they are in violation of their contract. They might have to end up paying defense costs for all these entities and whatever, but the company in court didn't have to do it. So is there a solution? And ISO, well, this has always been the solution, the specified insured. You can type in whoever you want. You get premises operations, maybe you can get an older edition, but I can type in whoever I want. Or ISO in 2013 created a second automatic additional insured version. And it says, additional insured, owners, lessors, contractors, automatic for other parties when required in a written construction agreement. And it does two different things. Who is an insured? Well, any person or organization that you have signed the contract with, just like the 2033. But then it says, any other person or organization you are required to add as an additional insured under the contract or agreement. So this endorsement automatically will follow and make additional insureds any entity that's in that contract. I can't guarantee. Can a company honor your contractual commitment of all these other entities with the CG 2033? Yeah, it can. And did companies do that? Yeah, they did. But there's been at least 2 court cases where companies didn't do it and they won. So if companies have case law showing we don't have to do it, could more companies renege on all of the entities that you sucked into because you didn't read the contract or you just assumed? So to me, if I have an option, CG 2038 would be the automatic additional insured I want. If your company writes their own, you might want to see or ask them, oh, by the way, now, when my insured signs a contract and has assumed responsibility for suppliers or whatever else, does the fact that they only signed the contract with one entity suck all those other entities in as additional insureds? And if not, can you consider using this endorsement? It's been around for 5 years. Again, downside from the other entity standpoint, it doesn't say arising out of. And it does, and it limits you to the limit required on the contract, and you can't have anything you didn't ask for. Those are things that are good for my client, but at least all the litany of entities I said were going to be insured now are insured. So, who knew? And there's a BOP counterpart too. There you go. Okay. And again, to me, it makes the only option, but I only teach this stuff. I don't sell it, so I don't even know if it's available out there. But it was approved for use in 2013. So, somebody's got the hiccups, yeah? Okay, in the dark ages of insurance 10 years ago, if you were asked to provide additional insured status, the customer's name was printed specifically on an endorsement form and some sort of charge was billed. Okay. Now, all or most additional insured coverage is on an endorsement which says the coverage is provided if there is a written contract requiring the coverage. Now, I guess I talked about this before. What is a written contract and with whom? So if you're a contractor, you may have a written contract with the firm who themselves is a subcontractor, but nothing of the GC, but nothing in writing with the GC. You had a problem with the CG 2033. You can only guarantee that if it's automatic additional insured, that the entity you signed the contract with is an additional insured. Does that other entity, so you're the sub and they're the sub, and they're contracted with the GC, I don't know. It's up to the company as to whether they want to honor your litany of additional insured suggestions. And again, to me, the CG 2038 would be sufficient. Second question is in regard to non-contracting risk, purchase of goods from a distributor. Does a purchase and sale order, which contains a clause that seller must provide purchaser with proof of product liability coverage and provide purchaser additional insured status under seller's general liability coverage, constitute a written contract? I searched prior TikTok, but I did not see anything currently on the subject, and you probably won't either. But it's in this. So as a purchase and sale order, activate.
That's a written contract.
Now it's a written contract. So as far as ISO is concerned, additional insured, any person or organization for whom you are performing operations. And with completed operations, if you just add the endorsement, then they're an insured and doesn't even care. So could a purchase and sale order be a written agreement? Absolutely. It's in writing. So it's us that think, it says contract or agreement, and that has been litigated, that, Naylor versus Navigators Insurance Company, 2013. The company didn't think that what was signed was a valid contract. And the court said, yes, it is. If you want some kind of you shouldn't have put the word agreement in. Just put the word contract in. But you put the word written contract or agreement, it's in writing, it discusses, it's sufficient for us, ambiguities found on behalf of the insured. So there you go, agreed in writing or a contract. Court concluded that the insurer had not clearly established that there was no basis for coverage under the endorsement. Of course, it had to go to court, which is unfortunate, but from a declaratory judgment standpoint, companies will bring it to court. I might need a lawyer for that, but if the court says shut up and defend the claim, then they're pretty much on it. So court's reasoning was based on the additional insured endorsement requirement of a written contract or agreement. So there you go. If you want something to be restrictive, then you should define it. If you're not going to define it, then we're going to go to dictionary.com or Webster, and find out what a definition, a normal, reasonable definition is, and there you go. So sometimes courts are actually our friend. I thought this was an interesting question, and I see that I forgot to leave out the company's name, and it's, I didn't mean that. Fentanyl. It's an opioid crisis. But this was interesting. Somebody went into the men's room in the Marriott or wherever, and did some fentanyl and left stuff there. When the police arrived, they were told management that the drug use was a particular kind. It posed great danger to those that might come in contact with it. Yay. And instructed management to call professionals to clean the room. Well, they called a few professionals and nobody wanted to come out. Well, that's always good, yay. They finally found finally they connected with Aftermath, blah, blah, blah. And the cost was $2,800, which was below their deductible for property. But they wondered what if somebody else went into the bathroom afterwards and touched this stuff, and then it got in their skin or in their mouth or whatever. Because if not handled properly, could he have unknowingly exposed his employees, well, that's workers' comp, yay, and his customers to injuries or death. Workers' comp, good thing. Customers could be problematic based on the policy. Insured as a standard company X, in your book it really says who the company is, but up here I changed the name. Because it really has nothing to do with the company. Because there was no claim, but it's just, it's our opinion that an adjuster would attempt to use the pollution exclusions to deny coverage. Could that happen? And it could, if you read that, that emanates from the premises, we give back, is that what the pollution exclusion was designed for? And of course, the agency, we're thinking about this at Hub, we suggested environmental policies probably is the way to go. Well, you're a restaurant, or you're, just a little convenience store, or whatever, and you have a public bathroom. Are you going to, if you really look at everything else, environmental policy, when you think of environmental policy, I think of pollutions that are going to emanate from my premises, like oil and glop and all that. It's like, wow, well, the cost of cleanup would be excluded on the property side of the policy because there's no loss, there's no physical damage, and we only pay debris removal. We have damage to covered property. And we don't have any damage to covered property, we just have a mess. If employees get injured, well, that's workers' comp, life is good. We're covered for that. But if a customer got sick, wouldn't that just be a liability claim? Would the pollution exclusion, number one, would the company invoke it? We don't know. We're just always thinking about what we're not going to cover. And will it be denied by the pollution exclusion? Pollutants means any solid, liquid, gaseous, or thermal irritant or contaminant. Would that be fentanyl? I mean, it fits it. I mean, the coffee you drink is a pollutant. I mean, everything is a pollutant. If you really look at this definition, any solid, liquid, gaseous, or thermal irritant or contaminant, including smoke, vapor, soup, fumes, acids, alkalis, chemicals, and waste. I mean, milk is a contaminant. If the milk truck rolls over and goes into the city water supply, I mean, anything could be a pollutant. But is that really what the pollution exclusion and the general liability of BOT policy was intended to aim at, really? And so I went to, I like IRMI, they do a good job at commercial lines. And and Bill Wilson from the IIABA, it's like, okay, so what's a pollutant? Is oil pollutant? Yeah, but if you drop it on the floor and somebody slips and falls, should that be denied under the pollution clause? No, really, no. And on the other hand, if the oil has escaped from a refinery storage tank and caused widespread environmental damage, is that the purpose of the pollution exclusion? And I think a reasonable person would say yes. And that's pollutant. So, and so I agree, claims fall in between, and they brought out a court, a few things that a few judges said, Supreme Court, Potter Stewart. I shall not today attempt further to define the kinds of materials I understand to be embraced within that shorthand description of pollution, and perhaps I could never succeed in intelligibly doing so, but I know it when I see it. And that actually when I see oil in the water, from the oil tanks, or oil disseminating from your oil tank and going into the ground, well, that, I think any reasonable person would look at that as being an environmental pollutant. I see it with my eyes. And in two recent appellate cases, decision just as the Massachusetts Appeals Court, amazing, in essence, that they know pollution when they see it. Massachusetts case, claim brought against a manufacturer of rubber products after it was discovered that fires in its stockpile of rubber had allowed toxic hydrocarbons to leach into the soil and groundwater. That's environmental pollution. That makes sense. So in Massachusetts, historically, we've looked at it as being an environmental pollutant. So industrial environmental pollution is a type of classic pollution case. It's the kind of pollution that reasonable policyholders know when they see it. But that's the best you can do. I mean, short of asking the company. So, you know when you see it. Or a similar line of reasoning, a subcontractor employees were injured when they were directly exposed to a liquid catalyst that escaped from a burst hose while the catalyst was being pumped into a cracking unit at the refinery. So the insured did not notify the insurer of the incident until it was served with a complaint. Well, you know, again, the insured argues that the conflict between the coverage afforded under the general terms, you know, creates an ambiguity. The insured asks to resolve this ambiguity in favor. This policy was intended to exclude only the cost of traditional environmental spills or discharges when normally associated with environmental discharge. If something just happens while I'm doing an operation, is it necessarily an environmental? So, and again, the circuit court said the very fact that the insured and the insurer were able to offer conflicting yet compelling interpretations established the essential ambiguity of this policy. So I don't have an answer, but I don't think fentanyl in a bathroom is really what the pollution exclusion was designed to exclude. But as an adjuster for a company told me, you don't pay claims, Irene. And I said, obviously you're not either. But you know, this is an interesting concept. In my heart and soul, with all the reading I've ever done, the pollution exclusion was not designed for somebody shooting up in my bathroom, leaving the leftovers there, and some other customer coming in and touching it and getting sick. That was not what the pollution exclusion was designed for. Sudden and accidental. And then we, you know, lawyers blew away sudden and accidental. I mean, the manufacturer was throwing glop in the river day after day, week after week. But, oh my God, today we found out we polluted it. So it's sudden and accidental from our standpoint. Well, come on now. That's environmental pollution. The world is just causing problems for us. So common sense, which doesn't always happen in company adjusting. I don't know. So again, to me, fentanyl injury to a customer seems to fit this, but I don't see it as traditional pollutant. And you know, you can buy an environmental policy that is for traditional pollution. If you look at what it covered, you just bought another policy that probably wouldn't cover that situation. So, sometimes you give me questions that are just makes you want to go, and there is no, if your CGL or BOP doesn't cover that situation, I'm really going to bet that the pollution policy that you bought isn't going to cover that situation. By definitions, I've looked at some environmental policies in the language, it's for, as that judge said, I know it when I see it, it's for traditional pollutants. So just lock the bathroom door and don't open it up to the public. I don't know. Okay. If a contractor builds and that's a typo, a deck, not a desk, and 5 years later, the deck collapses and several people who are on the deck gets injured, and yay, boom. If the contractor recently retired and has no insurance, would the insurance carrier he had when he built the deck pay the claim? No, it wouldn't. Because pretty much, whether it's a BOP or CGL, I need a policy enforced on the date of what? Loss. Incident. Not on the date I built it, on the date the incident happened. The contractor has coverage. If the contractor has coverage, would his current insurance carrier pay the claim or the insurance carrier he had when the deck was built? So if I didn't retire, if I buy a policy every year, which policy pays the claim? A policy enforced on the date the loss happens. And even if you buy claims made, as long as the retroactive date is here, it's still going to be the policy enforced when the claim is made, which will never, you know, unless it's the same year as you built it. When you built it is immaterial, unless the claim happens in the same year you built it. So, I need a date of injury. And so the current carrier, and the agent said, but that's not fair. Well, you know, If I change carriers, I had the same company for 5 years. I changed to a new company. The debt collapses this year. What company gets to pay the claim? Lucky company, the policy in force. So it's, they haven't collected the premiums for years. Well, it's really too bad. Bet they won't renew you either, but still, they're on the risk. Oh, that's not true. Just so I understand 100%, if the contractor retires and has no coverage, the date of the injury, the policy he had in force when he built the deck would not cover the claim. Yeah, you got that one right. When I retire, I still have responsibilities for things that I did. And again, as I said earlier, in Massachusetts, I have responsibility for how long? 6 years from the date I built the last thing. Yes?
In a case like this, we're assuming that it collapsed because of some way he built it, not that it was some other reason why it collapsed.
Well, I mean, he's going to be brought into the claim one way or the other.
Right.
And from a defense standpoint, and even if I have a little bit of responsibility,
Right.
I might have to pay out something. So I want a policy in force.
Switching carrier is not an issue, but how about gaps in insurance? Goes 1 year, retires, goes 1 year without it, or put it back on.
I mean, that would be why company, he asked if I had a gap in coverage, so I had 2 years of coverage, and then I didn't buy an insurance policy for 2 years, and then I bought another policy. That was one of the reasons why claims made was created. So if you chose to stop buying insurance, then we'll say your claims made policy, but we'll have a retroactive date effective today. But even still, that's not going to work. They're still going to pay it. The company, if your insureds get canceled for non-payment and then go back, do companies get sick of that after a while? Do they have a problem with that gap? And might we charge you more because we're on the hook for stuff? So, but as long as claims made, even still, retroactive date, doesn't matter. The injury happened if I have a valid claims made policy, so forget what I said about claims made. As long as I have a policy in force, I'm golden. Oh,
So say I retire, I'm a contractor, I built that deck, I retire today, so 2018, I should keep an insurance in force even though I'm retired for 6 years? Or
if I retire, that's why being a sole proprietor is a bad idea. I believe you should be a corporation, LLC, because yay, the world is stuck. But a lot of people are still sole proprietors. There's two options. I buy a policy for 6 years, but then the company says, and how are we rating this? Or there's a specialty market called the discontinued operations policy. It's kind of like you insure doctors. They retire, they buy a tail. That's what the discontinued operations policy would be. Tail coverage. So he does have a policy in force. But again, we need a policy in force, CGL or BOP. If you stop coverage, you get a problem. Policy in force. Okay. There's a little hint, I don't care. Oh, don't care when you build it, but when the incident happens. So whereas a specialty policy, discontinued operations. Or if a company would I could just say I'm in business and not do much, but discontinued operations. And I've seen that done. I prefer a policy, especially since we have a 6-year statute of repose, an open-ended policy. It starts today. It's one limit of insurance. And chances are, if I haven't had a problem in the last 20 years, chances are that I'm buying one last policy and it will be sufficient if something goes wrong. I wouldn't want a discontinued operations policy with a time limit unless the time limit in Massachusetts is 6 years from when I built my last thing. So it's why, I've seen one limit of insurance. I will have an inception date and open-ended. It's done when the limit of insurance is gone. Or 6 years, whichever. Because after 6 years, I don't care in Massachusetts, unless I did jobs in other states. And then would I need to know what the statute of repose is in other states? So, another way, if somebody bought my business Could I make them assume by contract? But I still would rather buy a policy in my name, so it does exist. Okay, boop. I left a message earlier this week. Oh, that means you left voicemail. Don't leave me voicemail. Not a good idea. I forget. But I at least have something on my phone now. It shows something so I can look that up. But whether property managers are considered insureds on standard ISO policies. Yeah. Or should they be added as additional insureds? Do you have thoughts on this? Well, I know that the ISO, CGL, and BOP in the who is an insured section say any person other than your employee or volunteer or any organization while working as your real estate manager. So our real estate managers working for you automatic insurance under your policy. That's what the CGL and BOP say. Not that we read the whole policy, but if we look at who is insured, they are insured.
So if you have a real estate agency that has a property manager, even though it has their own entity?
Well, if I have a real estate manager, real estate organization that has a property manager, are they an employee?
Yeah.
Then that's entirely different. I mean, this is later on. I think part of the who is insured, the first thing they say is employee. So if they're an employee, they're an insured. This is a separate organization that I hire as a property manager. Are they an insured under my CGL or BOP? Yeah, they are. Do they need to be added as an additional insured? You're already there. It's kind of like under the business auto policy, adding the additional insured endorsement, which if you read the who is insured provision in the business auto policy, it says anyone legally responsible for you or anybody else. They're automatically an insured. That's just a placebo in a way to give you a premium charge. So this gives them sole fault insured status if they are acting as named insured real estate manager for BI or PD to others. It says they're an insured. My employees are automatically insured. Volunteers doing stuff for me are insured in another section, but it says any person while acting as my real estate manager. Now, if I add them as an additional insured, they're only covered to the extent that I, the named insured, is at least 1% at fault. So technically, now you've got, to me, competing provisions on a policy. And that can be interesting, because then the company can argue the newest edition is going to supersede the older edition, and that's a legal theory, and I don't want to get into all that, but I have sole fault coverage automatically, but this says I'm only an additional insured if I'm if you're the named insured is at least 1% at fault. If I'm a separate organization, property manager, I'm doing stuff you might have nothing to do with the claim. I'm better off with this than being an additional insured on your policy. Just saying. Though, oh, what's that box? What's going to go? Oh, there you go. That's, some property managers want to be additional insureds in your policy, and they want the 2001 version because the argument is arising out of, can give them sole fault coverage, but I can show them the provision in the policy that says, you're an insured. Why do I have to add an endorsement to my policy to give you status that you already have for free, for a premium? Because I belong to the Property Management Association, and they said that I should be an insured on other people's policies. Well, you are. I can show you a copy of the provision. I think they're better off, sticking with it. So, another question on property managers. I need help with the interpretation of Form CG 2270. We have a CGL policy in the name of a property manager that has a CG01 form. Great. And then the company put that endorsement on. The underwriter states this endorsement adds coverage back on for the property manager. We are getting mixed interpretations of this endorsement. So what does this endorsement do? So this is the endorsement. real estate property managed, CG 2070. And it says this insurance does not apply to damage to property, property you operate or manage, or as to which you act as an agent for the collection of rents or in any other supervisory capacity. Does that remove coverage for damage you do to the property while you're at it collecting rents or managing it? Yeah, it does. I don't see how I can read this and say this gives them coverage. No. I mean, my basic CGL excludes damage to property my care doesn't control. But if I'm just there collecting rent and I manage to do something that damages the property, is it really my care doesn't control? But now I have no coverage because that's what this endorsement says. And then it says, oh, by the way, we are making your policy excess over the property policy or the liability policy of the people that own the property that you manage. So we're really saying we're going to pay fewer claims for you, and we're always going to be excess. So I can see why the company might want to add this on, but I don't really want it. But at least they're acknowledging, with respect to your liability arising out of your management of property for which you are acting as a real estate manager, this insurance is excess over any valid and collectible insurance. For any bodily injury you do, any damage other than to the property you manage, didn't we already say that the policy, the CGL policy on the owner made you an additional insured, or made you an insured under the who is insured section? So this real estate property managed, you've got an exclusion on it. Do we mention that? Unless you read it. So I don't know how you can look at this and say, oh, it's good for you. No, it's not good for you. It's good for the insurance company. It's not good for the real estate manager because they lost coverage that their generic CGL would provide. And we don't say the word exclusion. I think it should say exclusion for. So, hey, yay. If you're going to use this, I hope there's a whopping credit so that I went to IRMI just to make sure I'm reading, you know. And it says it does two things. It makes the property management policy excess over the primary policy where they have been added, it has been designated as an insured from commercial general liability or BOP. And then it says, is to make clear that the real estate firm's own CGL is not intended to cover any damage to the property of others that might be managed by the firm. So I said, yeah, I read it right. Yay. 2 points for me. And it's a free endorsement. It removes coverage from my policy. And the underwriter's telling the agent, but it's good. No, it's not good. At least I've got to tell them that it's. So can I? Real estate management agreements typically relieve the managing agent of liability for damage to the property itself. I hope so. Because this endorsement says we're not covering anything. So, I don't know. I'm trying to determine if coverage of the workers' comp or CGL can be obtained for injury to volunteers. From the information I am getting, it is not available. Do you get associations and nonprofits that want coverage for injury to their volunteers? Yeah, they ask. And I think that's very commendable that they should ask that. But you can't add it to workers' comp, right? Because if a volunteer is not paid, then they're not an employee, and if they're not an employee, then workers' comp coverage doesn't apply. And I've been to CICs and I've been to workers' comp seminars when they say, well, you could use a voluntary compensation endorsement and add volunteers on, and then we'll pay for injury, unlimited medical, because isn't that what workers' comp do? But obviously, if you don't pay them, we wouldn't pay them lost wages. And I said, not in this state, you can't. I raised my little hand. And because the Bureau wrote an epistle out on the voluntary compensation endorsement that it is not for volunteers. The voluntary compensation endorsement is for those elective types of employees like casual workers, whatever that means, or domestic employees that work less than 16 hours per week. You are their employer, but the law does not mandate you buy workers' comp. But if you have somebody come in and take care of your kid 15 hours per week, maybe you'd want to. That's what the voluntary compensation endorsement is for. So workers' comp is not going to deal with it. What I'd say is, if you have volunteers and they get injured doing stuff for you, can they sue you? And when they do, will your CGL or BOP respond? Sure. When your employee sues you, your CGL or BOP will not respond because you needed to buy workers' comp. But your volunteers can sue. And, you know, the employer liability workers' comp is all about employees. Volunteers might be insured when they injure other people, but if they get injured and sue you, your policy will defend and pay out if you're negligent. And I might suggest that you increase your medical payments to as much as the company will allow, because medical payments excludes injuries to employees and other insureds, but makes an exception for volunteers. So I would load up my medical payments coverage. Then maybe if you want to, you can buy an accident indemnity policy, but other than that, there's not much you can do. And boop, one last thing and it's time to go. I have a US-based manufacturer and installer of machinery who will be hiring a Canadian subcontractor to perform installation in Canada. Okay. My underwriter is telling me that no premises or operations coverage would be afforded for this Canadian sub, and rather coverage would be limited to products sold in Canada only via the following. Do I have premises and operations coverage in Canada? Coverage territory means United States of America, including territories, possessions, Puerto Rico, and what? Canada. You know, the underwriter is looking down below about products. I have worldwide products coverage if I make the product in coverage territory and I sell it in Japan and somebody in Japan gets injured, when they sue me, would my policy respond? Yeah, because I made it in coverage territory. Or I, you know, made my product in Peru but sold it in the United States. So they're looking at the wrong thing. Up here is my premises operations. Canada is a country we know and love, and our policy works there. So I disagree, and I agree with you. You got to go up in the coverage territory. Canada is fair game. If you're doing operations in Mexico, you got a little teeny problem there. You need the coverage territory definition. So, but I did say, by the way, that subcontractor is not an insured under your insured's policy unless you added them as an additional insured, correct? Because your policy covers you, and covers you when people doing work for you get you sucked into a claim, but they're not an independent contractor is not an automatic insured. I'd have to have added them by endorsement. But anything that's done in Canada on your behalf, you're covered. It is coverage territory. Life is good. Hey. Okay, there you go. Boom, boom, boom. There we go. I'm Earl at massagent.com, and y'all got to do your last sign in, and y'all can go have a drink here. You back there, you can go to your own house and have a drink. Okay, so the last sign in. There you go. Thank you very much.